Good morning. Thank you for joining us for this session, which is focused on setting up your new business and some of the key considerations that you need to consider from a corporate and commercial law perspective. I'm Melissa, and I'm a corporate law solicitor, and Alex, my colleague, is with me, who is a solicitor within our commercial department at Harrington Carmichael. Before we kick off, it's worth giving you a bit more information about Harrington Carmichael, and we are a full-service law firm offering advice to startups as well as large corporate businesses. The firm has recently been rated as a leading law firm by the Legal 500 Legal Directory, and also has been listed in the Times Best Law Firms 2024. It's worth noting that there are a number of advisors within the firm with different areas of expertise who would be happy to assist you with your legal requirements as you start up your new business and progress it in the future. In terms of format of this session, we are going to cover some key considerations to include settling your new business structure and what key documents you should look to have in place from a commercial law perspective. Finally, we will conclude with a Q&A where any queries that you may have can be raised with us directly. From a corporate law perspective, I'm going to start by providing you with a general overview of business structures, and there are 6 business structures in particular that I'm going to summarise initially. We are then going to look at 2 structures in particular in more detail, which are the most common structures used for startups, to also include covering some advantages and disadvantages of each. Before I summarise some of the business structures available, it is worth pointing out that each individual will have their own tax position to consider, and we would recommend taking advice from an accountant to determine which business structure is best for you from a tax and an accounting perspective. Moving on to business structures. The first structure I wanted to talk to you about today is the sole trader structure. And firstly, you could set up with this structure, which is an unincorporated business structure, where a person owns and runs their business as an individual. You could also consider a company, and there are 3 types of company I wanted to mention today. And a company is a separate legal person from its founders. And the first one we should take a look at is a company limited by shares, which is an option. This type of business structure can either be a public or private limited company, the key difference being that the share capital of a public company will be traded on one of the key stock exchanges. And so the private limited company is the company that we'll be covering in more detail today, as this option will be most relevant to you. The second type of company that I wanted to touch upon is a company limited by guarantee. And this type of company does not have a share capital and is most commonly used for not-for-profit organisations. If your main aim is not profit and your main priorities are either items such as the community or the environment, then there may be other structures that we could look at separately. It's worth bearing that in mind, depending on your aims for your new business. And finally, in terms of companies, the unlimited company, which involves a company which does not have any limit on the liability of its members, and these are a lot less common to see in practice. Finally, there are 2 types of partnership I wanted to mention, and the first is a general partnership, which is an unincorporated business structure, which occurs when 2 or more people run and own a business together with a view to make a profit, and these are less common in practice. And finally, a limited liability partnership, also known as an LLP. This is the most popular choice where a partnership business structure is chosen and is essentially a hybrid between a general partnership and a limited company. Now, the most common business structures that we see in practice utilised by startups include a sole trader and a private limited company by shares. I'm therefore going to focus on the 2 main structures for the purposes of this session, but you're welcome to contact me separately after the session if you have any queries about any of the types of business structure that I've mentioned. We will compare both and also look at some advantages and disadvantages of each of those 2 options for you. So we first look at the sole trader business structure. As mentioned previously, setting up a sole trader business structure is an unincorporated business and is currently the most common business structure in the UK. It is typically used where there is only one business owner. A sole trader setup is typically where someone decides that they want to start a business and choose not to operate via a limited company. For example, someone selling products on an online marketplace without putting a business structure in place would be considered a sole trader. Interestingly, as at September 2023, there were 3 million sole traders operating in the UK, and we'd just like to touch on some of the advantages and disadvantages of this business structure. So firstly, we look at the advantages. Setting up as a sole trader does have low registration and startup costs. And in addition, there is more privacy as there is no visibility of the business filed on the Companies House public register. It also may be an attractive structure as it's got simplified taxes and no corporation tax, as corporation tax only applies to limited companies. And there are also fewer accounting obligations. So you'll need to prepare a self-assessment tax return for HMRC, as well as a VAT return, if applicable, where your annual turnover exceeds £85,000. But on the whole, the obligations are lower than what you would have to do if you had a limited company. There are some disadvantages to this setup. And the first one is that a sole trader business setup results in unlimited liability for the business owners. Now, what that means is that if there are any claims made by customers or suppliers, for example, against your business, these will be made against the sole trader personally. And this in turn puts the sole trader's personal assets at risk from any business-related claim. Now, there may be some insurance policies that you can obtain via an insurance broker to reduce the risk, but this typically is the biggest disadvantage of this business structure. You also have to bear in mind that you'll have sole responsibility for the business, and where you grow and wish to introduce other business owners or investors in the future, you will need to change your business structure. I'd also add that in practice, we have typically found that it's more difficult to get funding, as funders and investors may typically expect to see a more sophisticated business structure. And there are also fewer tax planning opportunities and less flexibility to defer paying yourself an income. So for example, with a limited company, you can often retain profits in the company so that you could take your dividends or income out at a later date, which is not possible with a sole trader structure, so is worth noting. In summary, you may be interested in setting up as a sole trader if you would like to go for a low-cost option in terms of setup, but are comfortable with a very high risk of personal liability. Moving on to the private limited company by shares, it's worth noting that a limited company business structure can be used for both a sole business owner or where there are multiple business owners as well. This is the second most popular choice of business structure in the UK. And as at September 2023, there were 2 million active private limited companies in the UK. With this structure, you will have shareholders who are the owners of the business and they'll hold shares in the company, and then separately directors who will manage the day-to-day running of the business. We now have a look at some of the advantages of this type of business structure. One of the disadvantages of the sole trader structure was the founder facing unlimited liability exposure. And this is one of the advantages of setting up as a limited company instead. The limited company itself is treated as a separate legal person. So unless the founders enter into any personal guarantees or agree to be exposed to personal liability, then any claims against the company will typically be made against the company itself and not the founder. In addition, there is more chance of obtaining funding with a limited company, as lenders are typically more willing to lend funds to a limited company, as mentioned previously, as opposed to a sole trader setup. We'd also add that it's straightforward with a limited company setup to introduce new business owners to the structure if you grow and evolve later down the line, as additional shareholders could be introduced pretty easily later down the line. It would also be easier to sell the company in the future as opposed to a sole trader business, due to the fact that the company has limited liability status, which we've been discussing. Often we have found that in some areas and sectors, there has been greater credibility placed in some industries on a limited company rather than a sole trader setup. And as mentioned previously as well, it offers flexibility to leave profits in the business. Some of the disadvantages of the limited company business structure, though, include it is more costly to set up and maintain, but this can be future-proofed to an extent, and any business that does intend to grow, as mentioned, is likely going to have to become a limited company or implement a more formal business structure at some stage. So planning from the beginning could save cost and retain value in the long run if you are setting up your business and do intend to grow later down the line. There are some more time-consuming administrative and tax obligations with the limited company setup, including both filing at Companies House, which is a legal requirement, and also with HMRC. I'd also highlight that the business information where you set up as a limited company is available at Companies House, which is a public register for limited companies online. So it is less private than a sole trader setup. And the law requests that a number of different documents and information has to be filed relating to your company during the life cycle of your company from incorporation onwards. So it's something to bear in mind. Finally, as a limited company is run by the directors, as mentioned, there are legal responsibilities under the Companies Act that apply to all directors of a limited company, which, if breached, can have criminal implications. So in summary, whilst the private limited company does have some increased costs, both in terms of setup and the maintenance during the life cycle of the company, you are likely to consider this option if you would prefer a lower risk of personal liability. Now, once you have chosen your business structure, you may need to consider additional documents being prepared from a corporate law perspective. For example, if you decide to have an incorporated business, such as a private limited company by shares that we have been discussing, then you will be required to put in place documents in order to regulate the businesses which HC can assist with. If you opt for a limited company structure, you will need articles of association prepared, which are the rule book for the company, and this document is required from a legal perspective for all companies. In addition, if there will be more than one business owner and one shareholder, then you will also need to consider putting in place a private contract between the shareholders and the company, and this is known as a shareholders agreement. These documents are fundamental as they will ensure that the founders have adequate protections and deal with items such as decision-making, succession planning, and regulating the transfer of the ownership of the business going forward. I'm now going to hand over to Alex, who is going to take you through the key considerations that you'll need to think about from a commercial law perspective.
Thanks, Melissa. So this part of the presentation, I'm just going to take you through some of the key trading documents you require, how to protect your brand, how contracts can be formed and on what terms, some key clauses to watch out for in your contract, and the data policies you require. What contracts you require will very much depend on what it is you are selling and the industry you are in. But the main point is to ensure that you have appropriate written contracts in place with your customers and suppliers. These can be terms and conditions of sale, terms and conditions of purchase, distribution agreements, software agreements, etc. It really depends on what business you are in. We'd also say that you should consider taking out relevant insurances. We don't advise on insurance, but please do speak to your insurance broker as to the relevant insurances you can take out to protect your liability at the outset. So what you may want to do from the outset is is to protect your brand. And one of the ways you can do this is by registering a trademark. And I've just set out some reasons here as to why you may want to do this. So a registered trademark gives you the exclusive right to use it for the goods or services you specify in your registration. So this prevents others from using the same or similar mark that could cause confusion or mislead your customers. The trademark registration empowers you to take legal action against anyone who infringes on your mark. This can involve obtaining an injunction to stop any third party from using your mark. It could involve seeking compensation for damages, etc. Your registration is published in a public database, putting others on notice that you own the mark and deterring potential infringement. A registered trademark is a valuable asset that strengthens your brand identity, and of course then makes it more recognizable. A strong trademark can significantly increase the value of your business, making it more attractive to investors and potential buyers. And it can create a revenue stream as well. So it can be licensed or it can be franchised, allowing you to expand your business reach and generate additional income. So moving on to contracts and how they are formed, there's sort of 4 main ingredients to form a contract, which you can see on your screen there: offer, acceptance, intention to create legal relations, and consideration. So I'll briefly touch on each of those. Offer, you just need to ensure that when you receive an offer, that the other party intends to be legally bound by it, and it's not an invitation to treat. An invitation to treat is sort of what lawyers like to use this wording as a way of explaining that a party was just inviting the other party to negotiate terms, and it wasn't actually a formal offer. In terms of acceptance, for acceptance to be enforceable, it must correspond exactly with the terms of the offer without any variation to its terms. It's generally the case that acceptance must be communicated to the offeror to be effective, although sometimes conduct will be considered as acceptance. For example, where a supplier does not communicate acceptance of an order, but they deliver the goods ordered and request payment, then they could be deemed to have accepted the offer through their conduct. However, conduct will only amount to acceptance of an offer if it is clear that the party did the act in question with the intention of accepting that offer. Intention to create legal relations then, that's one I'm only just going to touch on briefly, because there just needs to be a mutual intention to create a legally binding agreement, and this is generally presumed in commercial situations. Consideration, that may be something you've heard before, so that's just a legal term used to describe the benefit each party to a contract will receive. So this is often payment in exchange for goods or services, but it doesn't have to be. It can be anything of value that you get as part of a contract, such as equipment or work, for example. Usually it is payment. Consideration isn't needed if the agreement's kind of entered into as a deed. A deed is slightly different to a contract, as it is subject to different execution formalities. That's kind of referring to how the agreement is signed and dated. And any breaches of a deed will be subject to a longer limitation period under which a party can bring a claim compared to that for breach of contract. Important to note that contracts can be written or oral. So, for example, a contract can be made over the phone, or another example is when you purchase an item from a shop, then technically you have entered into contract. Of course, we would recommend that your contracts are in writing to ensure you can include suitable protections for your business, such as IP ownership, express termination rights, limitations of liability, etc. And we can come on to those points a bit later. Battle of the forms. So this is used to refer to a common situation that arises when businesses exchange communications with one another with a view to making a contract, and each party attempts to incorporate its own standard terms into that contract. More often than not, the last set of terms dispatched before the acceptance or performance will prevail. So this is known as the last shot fired in the Battle of the Forms, and they will tend to apply. The doctrine of the kind of last shot fired, though, can be displaced if the documents passing between the parties and their conduct show that they intended some other terms to prevail, usually terms set out in the correspondence, for example. In terms of how the supplier can increase the likelihood of winning the Battle of the Forms, the supplier can ensure that its terms are included in as many pre-contractual documents as possible and attempt to fire the last shot in the battle of the forms by ensuring as far as possible that the supplier's terms appear on the last document passing between the parties before delivering the goods. There are pros and cons to this approach. The advantage of this is that no time is wasted in kind of negotiating amendments to the supplier's terms, and that assuming the battle of forms is won, the supplier's terms will be incorporated without amendment. The disadvantage, though, is that the risk that the customer might succeed in firing the last shot cannot be entirely eliminated, in which event the customer's terms would then apply. To kind of mitigate this risk, what suppliers tend to do is they tend to include a prevail clause within their terms, which stipulates that where, for example, terms are issued by the supplier, these supplier's terms will prevail over any terms issued by the customer. But this clause in a set of standard terms, this is unlikely to be effective since the standard terms, and therefore the clause itself, will not form part of the contract because it would not have been accepted by the customer, where the customer is itself seeking to impose its own standard terms by means of a counteroffer. However, parties tend to use this, include this in their standard terms as kind of like a bluff clause for operational staff of the other party, into assuming that there is nothing to be gained from seeking to impose their own terms because of this prevail clause included in the supplier's terms and conditions. So I'm just going to take you through some of the key clauses in commercial contracts to watch out for, and I'm going to do so very briefly because there's a lot to get through here. But essentially, limitation of liability clause, this is probably the most fundamental clause in your commercial contract. It's one which lawyers will jump to straight away, as it tends to include the liability caps for at least one of the parties. Liability caps are extremely important as they set out the maximum financial liability of a party under the contract, subject to those liabilities which cannot be excluded or limited by law. So these are, for example, death or personal injury caused by negligence, fraud, or fraudulent misrepresentation, as no party can exclude or limit their liability for those items under English law. Typical heads of losses that are excluded, and you may have seen in contracts before, so things like loss of profits, loss of revenue, loss of contract. Loss of contracts is the value of contracts with other customers that might be cancelled or not won because of the supplier's failure to deliver, for example, and indirect losses as well. The level of the cap on liability, common starting points for negotiation are typically the contract price, if there is one, or an estimate of the total contract value, or a percentage of the contract value. Typically, we see between 100% and 200% seems to be fairly typical. What is included and excluded from the cap on liability? So the supplier will want most items under the agreement to be included under the cap on liability, but it is common for the most fundamental breaches to not be included. So, for example, deliberate breach or breaches of third-party intellectual property rights, breaches of applicable laws, breaches of confidentiality obligations or data protection obligations, etc. Those kind of things tend to be excluded from the cap on liability. Indirect and consequential loss. So this one I touched on earlier, but what this means is they're losses that don't arise naturally from the breach. So it's recoverable only if the paying party knew or should have known of that circumstance when the contract was made. And that's why these heads of losses, they're typically excluded because they don't arise naturally from the breach. Supplier will typically want payments of service credits to erode their cap on liability, or claims by customers, group companies to erode their cap on liability. On what basis is the cap ascertained? So the cap can be an aggregate cap, so it's a total fixed sum over the course of the contract, or it can be a percentage of the sums paid under the contract. So this increases the supplier's exposure as the contract continues and becomes more profitable. Or it can be a higher of a fixed sum and a percentage of the sums paid. So this gives the customer a more meaningful remedy if something goes wrong early on in the contract when the total fees paid are still low. They'll still be able to rely on that fixed sum. It can be a per year cap as well. So this can provide limited liability in each year of the contract, or it can be a per claim cap, whereby the cap on liability will apply to each claim or series of connected claims under the contract. IP ownership is another really important clause to include in your commercial contract. You may have seen terms before like background IP or foreground IP. So background IP is kind of the pre-existing IP which is supplied to the other at the start of a project. So it tends to be that each party will kind of retain ownership of their background intellectual property rights. And the foreground IP, so this is the IP that is produced during the project's creation, during the project's duration, sorry, and this tends to be more contentious. So for example, in a services agreement where the services result in the provision of deliverables, the issue of ownership of the deliverables can sometimes be contentious, and the supplier will sometimes want to retain ownership of intellectual property rights in those deliverables, particularly if the deliverables can be exploited for other customers. A customer, though, on the other hand, will sometimes insist on having the intellectual property rights assigned to him on the basis that it is paid for them, and therefore they want ownership of them. But where deliverables are not bespoke to the customer's specifications or requirements, or the customer doesn't intend to exploit the deliverable with any other third parties, the customer may be satisfied with just a license to be able to use those intellectual property rights deliverables. Termination. So what you might hear this word repudiation or repudiatory breach. So this comes from case law, and it gives every contracting party the right to terminate a contract instantly on grounds of the most serious type of breaches that go to the heart of the contract. It's been said by case law that it's a breach which has been said to deprive the aggrieved party of substantially all the benefits of the contract. Can a repudiatory breach be cured? So once a repudiation has occurred, it cannot be undone. Remedial action by the contract breaker does not remove the aggrieved party's right to terminate. Acceptance of repudiation. So repudiatory breach does not end the contract automatically. The aggrieved party may either terminate the contract, or they can affirm the contract and the contract continues. To terminate the contract, i.e. accepting the repudiation, the aggrieved party would need to comply with the relevant notices clause set out in the contract, if there is one. Any attempt to terminate the contract, though, when you did not have the right to terminate the contract, could actually result in you ending up being in breach of contract yourself. So essentially the point is, at the point you're looking to terminate a contract, or if you've been issued with a notice to terminate, then we would suggest that you take appropriate legal advice at that point. So there can be express termination rights included in contracts as well, which you may have seen before. So termination for material breach, for example, but material breach, that doesn't necessarily justify termination unless it amounts to repudiation. That's why people put it in their contracts to say terminate for material breach, and they can actually list out what breaches would amount to a material breach, such as breach of the confidentiality obligations under the agreement would amount to a material breach, for example. But there can be other express termination rights included within your contract, such as late on payment or insolvency of the other party, or if the other party business is sold, for example, and can terminate on that basis. You may have also heard of termination for convenience. So if a party has a right to terminate the contract for convenience, then they can terminate the contract for any reason at their own discretion. And finally, I just wanted to touch on the kind of data protection policies which you'll need to have in place. So as part of the UK GDPR, businesses must comply with the transparency requirement set out in the UK GDPR. So the transparency principles require all controllers of personal data to notify data subjects about their personal data handling practices through a privacy policy at the time that data is collected. So for an online business, that will usually be through their website privacy policy, for example. If you use cookies on your website, you'll also need to have a cookies policy as well in order to comply with UK GDPR. So for example, you must tell people the cookies are there, explain what the cookies are doing and why, and get the person's consent to store a cookie on their device. And also, whenever a controller uses a processor, there must be a written contract in place which also complies with the requirements set out in the UK GDPR as well. If a processor uses another organization, i.e. a sub-processor, to assist it in its processing of personal data, it needs to have a written contract in place with that sub-processor as well. If anyone has any questions, feel free to to jump in, and me and Melissa can answer any of those. We'll hang on for a minute or so in case you have any questions. What I would say, if you have any questions about the Entrepreneurs Hub here at Harrington Carmichael, you can email hub@hc.law if you have any questions in terms of how to apply, etc. Then please do get in touch.